the motion.
Second reading.
Madam Speaker, I move that the Criminal Appeal and Criminal Review Bill number 17 of 2025 be read a second time. Madam Speaker, this bill may appear at first glance to be rather technical in nature, but it speaks in fact to something fundamental: the right to a fair trial, and more specifically, the right to a meaningful appeal. It reflects this government's commitment to ensure that our judicial system is further protected and improved. It is our goal to ensure that the delivery of justice in our courts becomes more coherent, accessible, and fair. Madam Speaker, let me begin by outlining the broad aims of this bill. At present, process governing appeals in criminal matters is fragmented and inconsistent. Procedures are scattered across the Criminal Appeal Act and its rules, the Courts Act, and the District and Intermediate Courts Criminal Jurisdiction Act. This has led to confusion for litigants, unnecessary procedural points being raised and argued, leading to delays in the administration of justice. This government's promise to make justice more accessible includes making it easier for laypersons to understand the law. True it is, we abide by the maxim that nul n'est censé ignorer la loi. This makes sense. We abide by the maxim, but you cannot have someone exonerated from legal obligation simply because it is argued that he or she did not know what the law said. It is a basic principle of the rule of law. But we cannot be blind to the fact that in this day and age, the combined volume of all applicable acts of parliament in a country like Mauritius is simply enormous. Even the most seasoned law practitioner cannot claim to know all of our laws. So the question arises, how can we be fair to our citizens? The least we can do, Madam Speaker, is to make it easier for people to get access to the law, that is, dans le concret and physically. This is why my office is launching in the coming weeks a website where all the updated statutes in force in Mauritius will be freely available without complex signing procedures and without uncertainties about past versions and amendments. The regulations will be uploaded shortly after, given the sheer number of regulations which we must admit evolve continuously. The next step, and which I readily admit is less straightforward, is to make our laws easier to understand. There are times when this will not be possible because of situations where legal drafting simply needs the technical language that allows precision and finality. But there are, on the other hand, many instances where we can be clearer, where procedures are complex simply because of historical weight, rooted in reasons which are no longer relevant. In such situations, we must endeavor to make things simpler and more straightforward. The bill before the House today, Madam Speaker, aims to start this process for criminal law. It does so by consolidating all criminal appeal and review procedures under a single legislative framework. It simplifies the steps required to lodge and prosecute appeals, and it ensures uniformity of treatment, whether the appeal arises from the Supreme Court sitting in original jurisdiction or from subordinate courts. We are also introducing changes that will substantially improve the fairness of treatment of accused persons. For example, henceforth, there cannot be more than 28 days between the moment a person is found guilty of an offense and the delivery of his sentence by the court. We do not often realize, Madam Speaker, that there are today dozens of individuals who wait for months and, may I even dare to say, years in prison before learning about their sentence. with the risk that they could end up spending more time inside than what justice has decided or will decide for them. This is an intolerable situation which must be done away with forthwith. So, Madam Speaker, this bill may look to be simply a technical reform, but its effect will be felt. The more so when combined with all the other aspects of judicial reform which we intend to tackle, which is what we have promised in the government programme 2529, that is to reinforce public trust in the justice system. Madam Speaker, allow me now to guide the House through the main elements of the bill. Part 1 deals with preliminary matters. Clause 3 imposes an important new obligation. All courts must now notify a convicted person of their right to appeal immediately after delivering judgment. It seems obvious, but this step is not currently mandatory, and its absence has at times led to injustice. Often, when someone is not represented at first instance by a lawyer, by the time that he processes the fact that he has been found guilty, he starts telling people around him about his conviction and why he disagrees with it, that he eventually learns that he can appeal and how he is to do that he travels to Port Louis to try and meet counsel, where he will be told that he has got to get a copy of the judgment from the court in order for counsel to be able to advise him, and then for counsel to draw up the grounds of appeal, not after having had to pay a fee to the registry of the court to obtain such a judgment, and that finally he needs to see an attorney to actually lodge the notice of appeal. The 21-day limit for appeals has, more often than not, already passed. We simply must make this process easier, and we start here by making sure he knows from day one that he can appeal. Part 2 of this bill covers appeals and reviews before the Court of Criminal Appeal. Clauses 4 and 5 establish its composition and jurisdiction. Here I should point out that the creation of a separate Court of Appeal in terms of composition and location is a reform that we are still working on, as set out in the government programme. I stress that this new bill will work seamlessly, whether in the new system to be proposed or in the current situation where the Court of Criminal Appeal is composed of judges of our Supreme Court, where it also sits. Another important note here is that Clause 5(2) maintains that even acquittals following a jury verdict may be appealed by the DPP, but only in limited circumstances, where, for example, the verdict is unreasonable or a serious irregularity has tainted the trial. Clause 6 harmonizes and clarifies the procedure to appeal. The rule is now simple. Whether the appellant challenges conviction, sentence, or both, the deadline is 21 days from sentence. This replaces the outdated two-stage system before the assizes, where an accused party had to appeal against his conviction within 10 days of conviction and then await his sentence to challenge it, a source of confusion for lawyers and absurdity for all. This anachronism has to go too. Clause 9 introduces a clearer, better defined route for criminal reviews. The DPP may apply to the Court of Criminal Appeal for a review of an acquittal or dismissal where fresh and compelling evidence has come to light. A convicted person may similarly request a review, but here it is via the Human Rights Division of the National Human Rights Commission on the same grounds, that is, fresh and compelling evidence. This is a safeguard, not a second bite at the cherry. It is not a political tool, nor an appeal in disguise. But where evidence surfaces that is both new and probative, justice demands a mechanism for correction. Clause 9 provides for it. The role given now exclusively to the Human Rights Division reflects the fact that one cannot expect a convicted person in prison to go and obtain statement from witnesses or other forms of fresh evidence all by himself. He will therefore have the help of the National Human Rights Commission through its Human Rights Division. Part 3 mirrors the process of the Court of Criminal Appeal for appeals from subordinate courts to the Supreme Court in its appellate jurisdiction. Clauses 10 to 14 provide for composition, powers, procedures, and rules for such appeals. The goal, again, is uniformity. An important addition is the provision for a third judge to be appointed should the two judges, having heard the appeal, have opposing views on the outcome. This will ensure the avoidance of deadlocks, which too often these days just result in the decision being delayed until one side wears out. Part 4 addresses interim matters pending appeal: stay of proceedings, restitution of property, bail, custody of exhibits. Of note, however, is Clause 19, which rationalizes timelines for skeleton arguments: 30 days before hearing for appellants, 15 days for respondents, as opposed to 45 and 30 days respectively now as the law stands. The new time frame is more realistic than the current regime, which is in fact rarely complied with, and it will improve preparedness and judicial efficiency. Part 5 lays out the determination of appeals and reviews. Clauses 20 to 33 set out the powers of the appellate court, including the power to substitute verdicts, order retrials, amend sentences, or correct serious irregularities. Clause 34 deals with outcomes of criminal reviews. The Court of Criminal Appeal may quash an acquittal or conviction and order retrial if it is satisfied that justice so requires and that a fair retrial is still possible. Clause 35 mandates credit for time spent in custody pending appeal or review, subject to specific rules. This codifies a principle already recognized in practice and jurisprudence. Part 6 includes miscellaneous provisions. Clause 36 allows for extensions of time on application made. Clause 37 enables the Chief Justice to grant legal aid even when no formal application is made, a small but important protection for unrepresented litigants. Clause 38 affirms the role of the DPP in representing the state in appeals and reviews. Clause 39, Madam Speaker, regulates ancillary matters like costs. Clause 40 empowers the Chief Justice to make rules for implementation. Clause 41 repeals the Criminal Appeal Act and the Criminal Appeal Rules of 1954. And Clause 42 introduces necessary amendments to 5 statutes, including the Children's Courts Act, the Courts Act, and the Protection of Human Rights Act. Madam Speaker, what this bill offers is not innovation for innovation's sake. It is a codification of best practice along with rationalization. And here I should stress that it is the fruit of careful consultation with the judiciary. This is the kind of legislative work that can make our system function more smoothly, more fairly, and with greater certainty. More such work will follow from my office, driven by the impetus of this government. Madam Speaker, before concluding, may I take this opportunity to say this. We have not included in this bill mandatory time limits for judgments to be handed down by the courts, but we are strongly considering this reform as well in the not too distant future in a separate and comprehensive piece of legislation. We have already started consultations on this issue, and we will discuss more, particularly with the judiciary. We will respect the views of all stakeholders and the constraints faced by them. But the time to make it happen will come, and we will not waver. Justice, Madam Speaker, cannot be achieved if the path to appeal is so entangled in procedural thicket that only the most sophisticated or well-represented litigants can find their way through. This bill is part of our duty as legislators to prune those thorns and light that path. This bill may not enthuse or incite great debate, but it is an important one nonetheless. I commend the bill to the House.
Thank you. Seconded. Seconded.